Hello. Good morning. Good morning, everyone. So warm welcome to everyone to the second day of our conference, Progress in International Law, a Cursed Relationship. Also, warm welcome to anyone following us currently online, as this part of the program is live streamed and recorded. We are very excited that we will start today with the keynote speech by Judge Hilary Charlesworth, and the keynote speech is entitled Searching for Progress in International Law. Of course, Judge Charlesworth does not need any introduction, but I will nevertheless try briefly to introduce her. Hilary Charlesworth has been a judge at the International Court of Justice since November 2021. Prior to her election to the ICJ, she was Harrison Moore Professor of Law and a Melbourne Laureate Professor at Melbourne Law School. She was also a distinguished professor at the Australian National University. Judge Charlesworth has been a visiting professor at various institutions, including Harvard Law School, New York University Global Law School, UCLA, Paris 1, and the London School of Economics. Hilary Charlesworth is, of course, the author of a vast body of international law scholarship. She is widely known as one of the authors of the seminal article, Feminist Approaches to International Law. This paved the way for a new discipline in international law and was followed by a subsequent monograph, The Boundaries of International Law. Judge Charlesworth, the floor is yours.
Thank you, Julia, for that kind introduction, and let me thank all the organising committee for their invitation to be here today. I've been so impressed. I missed yesterday to my great regret, but just participating in the dinner last night and hearing some of the conversations, I have really been able to sense the energy and the enthusiasm in the room. It's so impressive and so energising. So it's wonderful to be here. And it made me feel very positive about the future of international law. Sometimes people of my generation can think, is that all there is? But to meet people with so many different ideas and thoughts, and of course we have the youngest generation, of course, with Caspar here, who we have great hopes for. But it's a huge pleasure to be here in this beautiful city. So I realise a keynote address usually has the advantage of starting and setting some broad themes, and now you've had all those wonderful papers. I've read the abstracts and some of the longer versions too. I feel I'm behind. I'm offering you some themes that I think have already been covered, but I hope anyway to be able to add a slightly different angle. So it's, of course, I think many of the papers have made the point, but since I was invited to this conference, I see the word progress everywhere, so it just jumps out at you. And it's a ubiquitous term in every single field, and of course in international law. And just dealing with, I just went through the court's catalogue on where progress appeared, and of course it appears both generally and in specific topics everywhere. And of course, it's also embedded in the language of the Charter of the United Nations, whose preamble, of course, refers to a determination, and the words are to promote social progress. And then the mandate of the UN General Assembly is to, and these are the words of Article 13.1, encouraging the progressive development of international law along with its codification. And of course, the General Assembly established the International Law Commission for precisely that purpose. So I was very interested, of course, once I started to think about the theme more, that the conference theme departs from the usually celebratory linkage of progress in international law with its question mark. First of all, it uses the very powerful adjective cursed, which suggests a deep-seated failure of the relationship between progress and international law. It implies that there's not only that there's a relationship between the terms, but that this is a doomed, toxic conjunction, and that international law is always likely to be regressive. So it might be said the idea of progress will inevitably disappoint, or indeed that it's going to mask deep-seated inequalities. And such a theme that was my introduction slide, but this is the one. Such a theme, I think, is echoed in the observation of the Belgian artist, obviously René Magritte. L'idée du progrès est liée à la croyance que nous nous rapprochons du bien absolu, ce qui permet à beaucoup de mal manifesté de se manifester. So this painting of Magritte's, which is called L'ombre terrestre, you can see, and my slide hasn't done really justice to this very arresting image, but this is Magritte imagining a beast with human attributes on a black beach, and you can see in the background there's a horizon. And some art critics have pointed out that the fact that this beast has some human limbs sums up some of our fundamental contradictions. The idea of humanity itself, driven since time immemorial by its desire for progress, and at the same time, it's a victim of its own self-destruction. So it seemed apt in this sense. But then if we look at the conference title, there's that question mark, a cursed relationship, a question mark. So it struck me that punctuation mark is doing a lot of work, adding a measure of doubt or ambivalence to an otherwise very dramatic proposition. So I've been wondering, as a belated keynote speaker, whether my role is to dispel that question mark. Should I reject the notion of a curse altogether and argue that eventually international law will be on the right side of history through the force of progress? Or is my task to confirm the hex? But so what I decided to do instead was to focus on the idea of a search for progress in international law in a more descriptive sense. How should we think about progress in law? Where should we look for progress? And what forms does it take? So the argument that I'll make is that, and again, I don't think perhaps these are controversial in this company after your first day, that we should be much more careful when using the language of progress and should be specific about the frame that we're using. And that secondly, progress takes many forms in international law. It's certainly not a linear or directional movement, but I think can be best understood as a shuffle with steps forwards and backwards and sideways. For that reason, I think it may be easier to locate progress in the interstices of international legal action rather than in its grand arcs. So if we just consider for a moment the idea of progress, what is it? And of course, I've become quite obsessed with this word. I always thought I knew what it meant, but of course it isn't obvious. One meaning of progress is simply change itself in opposition to the idea of conservation or preservation. So aphorisms that we often hear, you can't stand in the way of progress. This is often said in town planning contexts. Draw on that sense. So in that context, progress can be associated with new technologies that disrupt social orders. Yet another meaning of progress is to add approbation to the word change by gesturing at a moral or a social advance. So on that account, the antonym of such a meaning of progress is regress or decline. And Thomas Guterres, who of course has been present virtually, but he has done some very, very interesting scholarship since the days of his PhD about progress. And in his summary, in his chapter in the Concepts Book of International Law that I see some other speakers have also cited, I think he draws this useful distinction, Guterres, between progress with the uppercase meaning in the sense of the grand idea or narrative, and also in a lowercase or everyday meaning. So the latter sense, the everyday meaning, is evident in the way that progress has become almost a cliche of management culture, all those progress reports, and or the way that progress has been turned into quite a mundane verb, to progress an agenda, or a term, a particular memoir of mine, moving forward. These all have this sense of lowercase progress. Another really interesting observation of Thomas Guterres is that all varieties of progress talk, whether lower or uppercase, he makes the point they're theoretical all the way down. So the discourse provides in itself a frame or lens on any change of direction from the past. So for that reason, and I'm quoting Guterres here, he posits that any evaluative statement that uses progress as the benchmark of choice must be treated as a normative mode of speaking the world. So for that reason, I think we have to pay attention very closely to the nature of the frame that progress imagery or language imposes in specific cases. So my offering is to present 3 vignettes of progress in international law from different perspectives. And the first one I want to offer is visual. And it's the idea of progress represented in the windows of the Great Hall of Justice in the Peace Palace. And unfortunately, where we sit on the bench, I've been twisting, knowing that this talk was coming up, I've been twisting my head all week, trying to check out what if it fits what I'm going to say fits with this. But what's also difficult, as you'll see now, this picture that I'm showing you, some of you who know the court will see that it's ahistorical in itself because it doesn't take account of the new bench in the court, and also the fact that these windows of progress are now partly obscured by the screens to show your PowerPoints on. So there's a whole separate story of progress interrupting the story of progress at the court. So paying attention to the art and architecture of an international institution can reveal the expectations of its founders, and also the way that those expectations of the founders can continue to shape the expectations and the performance of institutions. And so many scholars now are drawing attention to art and architecture of international institutions. And of course, this move is to question the modernist separation between art and law, uncovering links between power, law, and images. So the art of the Peace Palace, as is quite well known, presents adjudication as this inevitable, this inexorable story of progress. So these 4 windows that you can see there were the gift of Great Britain, the United Kingdom, but interestingly for Australians, it was on behalf of the Commonwealth. So this was a gift from our colonial power on our behalf at the early part of the 20th century. And you can see that each one, and I'll be able to show you some more details, you can't quite see the first window, all of its panels, but each of the 4 windows itself has 4 panels. But you can see, I think from this photo, the way that those windows infuse the main courtroom with light. And these, of course, immediately have the resonance of cathedrals, and one can sense a quasi-religious atmosphere just from the way that they're placed. So the windows are called the evolution of the peace ideal, and they were made in 1914 by the Scottish artist Douglas Strawn. Strawn's idea was to depict the idea of peace as it advanced through 4 stages. The first one, the primitive age; second, the age of conquest; third, the present age; and the final set of 4 is called peace achieved. So actually Strawn has left us with really detailed notes. They're fascinating notes about what he meant in all the windows. But I think, and well, I hope that you can get a good idea of the meaning from just simply looking at them. So the windows are read from left to right. We have then a state of nature in the first windows, a crisis in the second, a transition, and a resolution, a very familiar progress narrative. So the windows overall tell a story of progress towards international adjudication, which emerges in the final set of windows as the marker of civilization. So you'll be able to see that Strawn invested his work with a lot of meanings. You'll see a lot of symbols, signs, and I don't know if you can see well enough here, but hopefully you can in a minute, that the colour scheme in each of the sets of windows changes. So what's interesting too, I hope you'll see, is that the Carnegie Foundation told the United Kingdom and kept reminding Strawn, we cannot have any Western religious symbols in here because we are meant to be international, so kindly leave out overt religious imagery. But I think you'll see that Strawn, his imagination was perhaps bounded by Western religious imagery, and a lot of it comes right back in. So he didn't have too many overt things. He tries to add signs of the zodiac and so on, I think, to stress the secular nature. But I don't think he manages very well to get rid of the signs of religion. So we can see then, this is the first window, and I do apologize. One thing this exercise has shown me is even in the court's records, we don't have really clear photos of each of the windows. So I apologize that some of these, I do have some close-ups of some of the panels, but a project I hope the court might embark on is recording these in better form. But this is the first one, the primitive age, and this is one of the close-ups. So you can see there that in the primitive age, Strawn is representing hunters, shepherds, and harvesters who are living harmoniously with nature. And at the bottom of the large window, there's a quote from Ovid, who declares that the banner says, "Man lived in peace without need of the military." And here are some more of the idealistic scenes of human nature in the primitive age. And these are some of the images from above the main windows, who are looking down. So that's the overall window. So you can't see very well there, but perhaps you'll just have to believe me that panel 3 depicts the discovery of fire, and then in panel 4 you have the discovery of metalworking. So, and above there are figures that start appearing with helmets foreshadowing conflict. So it seems as though Strawn is gesturing at the idea, well, the birth of some technologies, fire and metalworking and so on, sowed the seeds of the fall from this Garden of Eden. Then in the second window, this is called, you might remember, the Age of Conquest, and you can see here more red. This is the warlike red and the figure of Bellona. So Bellona, the goddess of war, has made the skies red. There are fires raging there, and there are symbols of hunger and death. And Labour, the figure of Labour, is tied to a wooden stake and is powerless to stop soldiers looting. So above them, in that series of 4 smaller windows above them, fighters are entering into battle. And what's interesting, if you could only see this better, is that the soldiers are all dressed in different national dress, but all carry the same banner. So there's a broken plough, and the conquered are forced to, this is a detail of the 2 final ones, the conquered are forced to drag the battering ram to destroy the fruits of their labour. But the final panel here, perhaps you can see this reference to this calm figure that's standing up, whose head is almost meeting the top there. This is, according to Strawn, a constructive spirit, a visionary who brings justice and hope to encourage humans towards peace. The third window, so the present age, shows the birth of the realization that war hinders peace, and that scientific developments, if we have scientific developments, these are going to rebalance the scales. So in panel 2, science is holding the goddess of war, Bellona, who's all chained up. In the third panel, you can perhaps just make out there the figure of science, and then in the fourth panel, it's philosophy and the arts who are preparing for peace. There's also a very interesting figure of finance there, who has one finger on a telegraph and who's gesturing at a bag of coins. So Strawn's interpretation of this third window, and these are his words, that he said this is a sign that international disputes should be settled between representatives and not by the meaningless massacre of whole races. And along the top, which is some very beautiful images of which it wasn't possible to get a better close-up, but they depict the search for mutual understanding and peace across the 4 quarters of the globe. And then we have, that's one of the details from that window. In the fourth window, this is peace achieved, this is the culmination, and Strawn said, peace marks the real beginning of man's higher development. So we can see here peace and justice rising from the ashes. There are the images of swords being made into plowshares. Lions are lying down with the lambs, so there's a lot of familiar imagery here. And perhaps in the top you can see there are doves, that all this symbolism are being put to use there. So it's clearly biblical iconography. So it does return a bit to the sense of the pastoral scene in the first window of the primitive age, but the difference here is this is a scientifically informed society. In the second panel, it's a bit hard to make out there, arbitration holds sway. I did sneak into the courtroom before I came and just on my iPhone tried to get better images, but I realized they were very, very blurred. So you can just see perhaps a tall figure there who's arbitration. And in the third panel, perhaps you can see peace is the seated virginal Mary type figure, and in her arms, Bellona, the goddess of war, is actually dying. So this is the end of Bellona. And in the final panel, international adjudication appears. This is the acme of civilization. Now, there has been some marvelous writing on these windows, and I particularly recommend a chapter by Daniel Litwin in, I think, that wonderful book, International Law's Objects, edited by Jesse Homan and Daniel Joyce. And he makes the arguments that I think are useful to people interested in progress, that the windows encode three major beliefs about international adjudication. First, he points out the idea that I hope you've seen already, that adjudication is essential to peace. Peace can only be achieved by law, and so justice and order, they're the only routes to curb the chaos of international politics. But what's interesting is it's not just any law. The windows definitely associate law with international adjudication as the highest form of law. Second, Litwin points out the windows also present international adjudication as themselves a sign, a marker of civilization. So in this sense, there's this almost anthropological account of history referencing the scientific positivist ideas of the late 19th century. So this meshed obviously with attempts by some positivist international lawyers to detach international law from the spectre of natural law and the evolutionary ideas that emphasize the value of science over belief. But there's also these, especially the final window is more complicated because it also harks back to the more anti-scientific, I suppose, view of international society as a romantic one. It's coming back to the idea of a pastoral society without weapons. So in the age of context, that's a barbarian society, but the one of peace is a civilized society. So states can only participate in international adjudication once they've reached civilized status and recognize as part of that war could be avoided. So using this, it reminded me of some of the language of Lasse Oppenheim, who wrote in 1908 that the science of international law requires and these are his words quoted by Litwin, a deep-rooted faith in the progress of the nations towards peace and civilization. So that idea structures the story of international adjudication. Litwin's third observation generally about the windows is that the windows overall present international adjudication as somehow above and beyond history. The idea that international adjudication comes out of a timeless past. So this is, you can see, I hope from the detail of the windows, the style, and this was very much in the romantic mode, the arts and crafts mode. Douglas Strawn was a member of the Scottish arts and crafts tradition, which built on the Gothic style of the medieval era, particularly in stained glass. So you have this complicated mixture that you have these romantic signals also referencing the role of science. So in that sense, I think the windows can be seen to reflect two contradictory approaches to progress. One is cyclical, going back, that's where we finally want to be in this pastoral society of peace with doves flying above our heads, and the other one linear. So the first one, the cyclical one, emphasises the legitimacy of adjudication through showing its long provenance back to time immemorial, but the other one is the culmination of struggles depicted in the earlier three windows. So the architecture and the iconography of the Peace Palace, I think overall, but you can perhaps see it here too, is very much based on Western values and encodes a very particular vision of civilization. What's striking about these windows that, of course, were designed for a building that, first of all, held the permanent court of arbitration rather than the permanent court of justice, is that it was possible for the symbols to be read as applying to a judicial form, even sort of 20 years after they were installed. So now these windows are read in a different context, but in a sense the idea of adjudication still is able to draw on this sense that adjudication is a form of dispute resolution that has these timeless beginnings. So even though the windows were very much a creation of their time, some of that symbolism and meaning still resonates today, the idea that progress consists of strengthening adjudication. And I think, although I won't dwell on this now, that some of the romance and optimism about international adjudication contained in Straw's windows, I think we can see elements of those in proposals that were popular perhaps 5 years ago for a World Court of Human Rights, some of the language, the Swiss proposal for that, and sometimes also the writings about various of the international criminal courts and tribunals reminds me of some of this romantic era, so I think it still has resonance today. So my second vignette is about access to international adjudication, so actually being in that courtroom with those splendid windows. So this idea that the arc of the moral universe bends towards adjudication isn't traced only in art. It's very much associated with progress in legal discourse. So in a legal system where adjudication has great status, it's perhaps unsurprising that progress is often measured through access to courts. So the idea is, I'm simplifying of course here, the more adjudicative fora there are and the more accessible they are, the more advanced the international legal system. And I'm struck now that I read rather obsessively any accounts, any analyses of the court's jurisprudence, how often these are cast in the frame of progress. And much of it seems to be, well, with the greater passage of time, judicial institutions are really going to pay greater attention to the reality of human lives. There is certainly a strand of scholarship that takes that line. So this is where my second vignette comes. So as far as the International Court of Justice is concerned, that story of progress is often told, and I'm sure I've told it myself as a teacher, and now I perhaps see it differently. I feel sorry for all my generations of students that had to put up with my stories that I now am having a radical rethought about, but this story is often presented. There are two cases, and of course these are the controversial judgment in 1966 in the Southwest Africa cases, and then redeemed by the auspicious obiter in the Barcelona traction case. So the overall story is there's a regressive institution that evades its duty to dispense justice, then a court manifests its willingness to ensure the protection of basic human rights. So, sorry, I need to, that's judges all sitting in the court. And the facts of the Southwest Africa case perhaps are extremely familiar to you. This, of course, revolves around the 1920 League of Nations mandate for German Southwest Africa, or rather about its application after the Second World War by the mandatory power South Africa. So the mandate, of course, in addition to obligations owed to foreign nationals, the special interest provisions, the mandate also imposed obligations on South Africa with respect to the treatment of the inhabitants of the mandated territory. And of course, indeed, it was precisely because of South Africa's alleged failure to live up to the conduct obligations that the 2 African states that have been members of the League of Nations, Ethiopia and Liberia, resorted to the court. So here is, and these were discoveries that I found in the court's archives. So this is an interesting photograph. This is actually the court sitting in the earlier phase of the case with the South African counsel appearing before it. And here is the court actually sitting during the hearings of the Southwest Africa case. And of course, Australians, I think I might be the only Australian in the room, we have a particular interest or perhaps guilt about this case because, of course, the president was the only Australian to have ever been present for court, Sir Percy Spender, and you can see him there in the president's chair. And so, of course, it was in this case that the court held that the 2 applicants, Ethiopia and Liberia, would have the right to invoke the responsibility of South Africa only if South Africa bore, the words were, a direct obligation towards the other members of the League of Nations individually under the mandate. And so the court, by the casting vote of the president, and I do have a close-up of Sir Percy here, I can't tell you that this is exactly when he was delivering the judgment, but on his right is the vice president, Wellington Koo, and on his left is the Polish judge, Winarski. So he's sitting there. But it was interesting for me to see that one, but the court was evenly divided, and then the casting vote of the president came up with this decision. So Ethiopia and Liberia famously did not have standing to challenge here. So 4 years later, in the case of the Barcelona traction case between Belgium and Spain, the court somehow rediscovered the concept of the international community as a collective whole, which is the beneficiary, the court said, in one might think an unlikely case there, rights of shareholders, which is the international community is the beneficiary of some fundamental obligations. So in that case, the court affirmed, and I think I have, this is the a photo of the court, I apologize, sorry, thank you very much, in action in that case. The court affirmed that all states have a legal interest in the protection of the rights corresponding to those obligations, and according to the legal canon at least, the court indicated that such protection can be implemented through judicial proceedings. So in terms of the windows of the court, we can see that the tension raised by Southwest Africa case is resolved and progress is achieved. But of course, one only has to zoom out a little bit to see that there's a much more nuanced or complicated picture. To begin with, the idea that states may have a legal interest in the protection of collective rights had been suggested right from the very early days of the Permanent Court of International Justice. Indeed, in the case which celebrates its 100th anniversary this year, the Wimbledon case. And yet that legal interest doesn't suffice in itself, according to the jurisprudence, to waive the fundamental requirement of consent to international adjudication, which is the basis for legality, but also, it must be said, for the legitimacy of the court's decisions. So this last point was illustrated in the case of armed activities, the DRC versus Rwanda, which was decided 35 years after Barcelona traction. And you may recall that in that case, the court held that the invocation of rules creating erga omnes obligations, indeed even of peremptory norms, couldn't compensate for the absence of a valid title of jurisdiction. We can see then a similar juxtaposition of cases very close to one another, one tension, one resolution. In the same year, 2012, just over a decade ago, the court affirmed in the Germany-Italy case, on the one hand, that sovereign immunity validly precludes the adjudication by domestic courts of claims concerning alleged violations of peremptory norms, and yet in the same year, in the obligation to prosecute or extradite, Belgium against Senegal, that all states parties to the Torture Convention can hold a state accountable for failing to prosecute the crime of torture. So we can see a shuffling movement, certainly not a clear direction. And there are many, many others in the jurisprudence of the court. We could think about the monetary gold principle, how it was diluted in phosphate lands in Nauru, a case, of course, in which Australia was a party, only to be reinvigorated 3 years later in the East Timor case, in which Australia was also a party. There can also be, of course, as the Barcelona traction case shows, a shuffle in the same case, because a few pages after the passage I've reminded you of, the large statement in Barcelona, the court was circumspect towards an unqualified right to protect victims of human rights violations. So my point is here, I think there are many, many other shuffles one can detect, but without a clear account of the benchmark by which progress is measured, it's challenging to determine which of these jurisprudential moves are geared at the direction of progress and which ones are really sailing against the wind. Moreover, we can see that, I think, on any measurement, progress doesn't take a linear form, but it can move forwards and backwards and indeed sideways. In any event, it seems to me we could question the association of progress with greater access to judicial institutions. As international lawyers, I think too readily we tend to assume that more law, more courts are a good thing. But of course, there are many, many other ways to regulate or to influence the course of events. So I think we can understand international jurisprudence, and certainly the jurisprudence of the International Court, as one thread in a tapestry of effective regulation or the way to influence the course of events. But this thread can break if too much weight is placed on it alone, and its strength depends on it being woven with other forms of regulation. These could include institutional and political pressures, publicity, activism by civil society, as well as art, architecture, and literature. My third vignette is the field of women, peace, and security, because this is often pointed to show an example of normative progress in international law. And this is the moment when the UN Security Council in October 2000 adopted Security Council Resolution 1325. So this was a historic resolution because it marked the first time that the Security Council, I'm quoting from resolution here, promoted the full involvement of women in all efforts for the maintenance and promotion of peace and security. And over the following 20 years, there have been I think 9 at last count, further resolutions of women, peace and security that have been adopted. And many of you will know that this whole scheme, Women, Peace and Security, builds on existing regimes of international law, from international humanitarian law, human rights law, international criminal law and refugee law. It's often told, as said from a feminist perspective, it's a success story. And Radhika Kumaraswamy, who 7 years ago now did a major study of the effect of 1325, she described the resolution as, and these are her words, the focal point for galvanizing worldwide efforts to deal with the many challenges that face women in situations of conflict. So it's certainly true that women, peace and security, this whole agenda which comes on every year onto the Security Council's agenda, has generated normative changes in the international landscape. So certainly, and the next images I've taken from various websites that are dealing with the implementation of 1325, so they're all specifically tied to it. This is one appears. It's underscored, as you see here, the importance of women's participation and representation in decision-making with respect to conflict prevention, management and resolution, as well as in peacekeeping field operations, transitional justice processes, and as special envoys and representatives of the UN Secretary General. The Women, Peace and Security agenda has recognised sexual violence in particular as a tactic of war that, and these are the words of the relevant resolution, significantly exacerbate situations of armed conflict. It's also been seen as sexual violence as a tactic of terrorism. And so the agenda has become very much, in more recent resolutions, focused on sexual violence. It's not just something that stayed in the Security Council, it's been amplified through many regional organisations, the African Union, the EU and NATO, and incorporated into military training and foreign policy. However, I think the apparent success, the broad success and acceptance of this agenda illustrates the simplification of feminist ideas. So in using the language of gender and urging a gender perspective, the UN Security Council, in the whole suite of resolutions, has confined the meaning of gender to women alone, and these women are assumed to have special needs in post-conflict reconstruction and in protection from sexual violence in armed conflict. So, for example, we can see there are only 2 fleeting references to sexual violence against men in this suite of resolutions, and there is no reference at all to harms to other persons directly targeted for their sexuality or gender identity. So women and girls are in the frame, and they're portrayed largely as permanent victims in protection, in need of protection by, one assumes, male peacekeepers and military forces. Their experiences of conflict are largely reduced to their sexual vulnerability rather than to any other conflict-related harms such as displacement or to pre-existing inequalities and disadvantage. Through the WPS agenda, international law has come to fashion particular images of women that come within its gaze. So we sometimes have, as you see in this image, women members of the military who are seen to have special access to women in particular societies. But we see a lot of the images are the vulnerable mother with children. And there's another sort of favoured images which is of the woman as the local stalwart who will detect early signs of radicalism and terrorist tendencies in their sons and spouses and in the wider communities. Now, such, I think, limited image may be inevitable in legal systems that operate with a unitary subject and factor out the intersection of complex forms of inequality. So, on the one hand, we can see in Security Council Resolution 1325, there's a signal that the issues of women's lives in conflict-afflicted zones came into the most powerful body in the international legal order. And certainly this was the reason why the Women, Peace and Security agenda was promoted by women's civil society as a women's human rights agenda, but also importantly a women's peace agenda. But what's striking, if you follow the resolutions over time, that the women's peace agenda has almost entirely disappeared. There are only passing references in the whole suite of women, peace and security resolutions to conflict prevention, and there's very little attention in how to make or sustain peace. So it's striking that when Radhika Kumaraswamy did her 2015 global study on the implementation, which for those interested I recommend, it's a marvellous and detailed study, she reports that in fact when women around the world were consulted on what they wanted, from 1325, they called overwhelmingly for an end to militarisation and for prevention and protection through non-violent means. But it seems as though, in fact, the Women, Peace and Security agenda, at least at the level of high politics in the Security Council, has been securitised through the Council's call for the inclusion of more women in military bodies, for protective military action, and the integration of women, peace and security with agendas for countering terrorism and violent extremism. This is a Pakistani special women's force to deal with terrorism. So I think a very striking image. So we can see that over 20 years after its adoption, the implementation of these resolutions remains fragile. In fact, it's been undermined by gendered institutional cultures. So it's very striking. I read each year the Secretary General of the UN puts out a report around October on Women, Peace and Security. And these are incredibly interesting documents, and they tend to be very frank. And in his most recent one, which just was published last year, his 2022 report, and I quote from him here, he says, against a backdrop of increasing violent conflicts and reversal of generational gains in women's rights, the Women, Peace and Security agenda is further from achieving its goals than ever before. So it's a very sobering assessment. Unfortunately, he doesn't go further than that, but that's sort of a signal that there's an acknowledgement, even at the highest levels of the UN, that this great advance has not delivered. So it seems that using a feminist framing, Women, Peace and Security may appear as normative progress, but its effect has been constrained by gendered institutional cultures. So progress here manifests possibly as 2 steps forward and 1 step back, or perhaps even 1 step forward and 2 steps back. So then, to conclude, to come back to our conference theme, the idea of progress animates much discussion of international law, and of course this is precisely what inspires and sustains many of us. I've always been struck by a statement by David Kennedy, who many years ago in an article in 1994, he described a distinctive attribute of international lawyers, which was, he said, their fervent belief in the discipline. And he points out that the discipline of international law, and here are his words, it's a project of reform as much as a field of study. At a minimum, David Kennedy says, such lawyers, international lawyers, see themselves in their work favouring international law and institutions in a way lawyers working in many other fields do not. He remarks, to work for a bank is not to be for banking. So I think that's an important point there, and it's something I certainly recognise. And I think it perhaps explains why the discourse of progress is irresistible to international lawyers. Altvicker and Digelman, in their very interesting article on progress talk, have observed that there's actually been a resurgence of progress narratives in international law over the past 2 decades. And their argument, which is very interesting, is that such narratives were more fraught in the 1990s and the early 2000s, when critical thinking in international law had more influence. So I take it that their argument is that with the retreat of such critiques more recently, progress talk is now back in vogue. So, returning to the conference theme, is the relationship between progress and international law cursed or doomed to fail? Well, I think that would be surely much too sweeping a proposition. But what I've tried to argue is that progress talk, it can be valuable, it can be inspirational, but we have to be clear about the measures we're using, the lens, the frame. And that second, that progress in international law rarely appears in linear form, and it rarely entails the construction of new legal principles. It is rather a shuffling movement, and I've been very struck by, in the architecture literature, the idea of the great repair that's now appearing in the architectural literature, which makes the point we shouldn't go for demolition, we should go for repair and mending. And I sort of would like to borrow that idea, with apologies to the architects who have a much more sophisticated account of it, that maybe we should be attending more to repair than to construction. So we can say then, I think finally, to offer an answer, that the relationship between progress and international law is not cursed, but neither is it charmed. It is rather a complicated relationship that's constantly being renegotiated.
Hello, can you hear me? Okay, so thank you very much for this thought-provoking keynote speech. And now we have a couple of minutes for questions and answers. So hopefully, please, who is willing to give the first question? Yes.
Yeah, thank you so much, Judge Charlesworth. This was super inspiring. And I have a question about your point on temporality and the temporality of progress, as you have argued that indeed progress in international law is not just linear, it's cyclical, or as you mentioned, follows shuffling movements. So I was wondering if you could elaborate on that and how the past, in a way, is somehow, how would say, is instrumentalized in a way that serves that, I would say, that idea of progress, because you mentioned this idea of the past as romanticized, as we can see from the windows of the Peace Palace, and so in a way, I would say, is not that the past has a meaning in itself, but it actually kind of, it is the present that gives meaning to the past, and in doing so, also laws is able to make a selection between different pasts that can be more useful to that, I would say, the project of creating that progress narrative. So how do you see this selection and going on? And yeah, I would say in this way, there is still a directionality involved, so an orientation towards the future, but where the past is also part of that story. Yeah, thank you.
Thank you, Eliana, for your question. I hope I can do it justice. I think that I would say that, of course, the idea of the past is highly negotiable. And this is, we know this from history, is that which past is being appealed to, and there are many, many pasts. And it's always of interest in, and one sees that very clearly in the Peace Palace windows, because there's these utterly ahistorical images that have been conjured up and drummed into, and of course, because many of them actually, the lion lying down with the lambs and so on, many of these are just directly from a particular tradition that would mean nothing in other contexts. So it's a highly negotiable thing. So it's interesting, the views of history that are taken up by international law, and of course there's been a lot of writing about that. But I agree with you, of course, that present gives meaning to the past, and that's what's going to be critical. But I think we have to understand all the eras as something that are not, that have a sense of choice and normativity about them. So I would just agree with that. And it's of course, one sees this in legal reasoning. This is not just in international courts and tribunals. We know that, say, in national court systems, obviously the Australian one is the national court system I know the best, but it's almost accepted wisdom that when courts want to look back at what they've done before to use that in doctrines of precedent, they will often just, it's often pointed out, they'll be highly selective. So the past is always curated in a very, very clear way. And one can see this. Sometimes one finds it also in, one can see this in court procedures. You can have something that's clearly written down as a particular court procedure, and what I've discovered since becoming a judge is that sometimes even the ideas of past practice on issues of procedure can be negotiable because people have different memories and there are different records. So I'm not sure if that's really responding to your thoughtful comment. But the idea of shuffling rather than, which is just the metaphor I thought of for what often happens is the sense that there can be a movement in shuffling, but it's a complicated movement. And if we understand that, I was just struck by some literature that's coming out recently about various decisions of the International Court that want to tell all the stories as though, understand this case happened and there were seeds dropped there and then these seeds grew and then they were somehow magically reaped by the court, they were harvested in this case. And you think, well, the story is surely much, much more. That's a satisfying narrative in a way, but it's one that I think I now understand to be much, much more complex.
Another question? Oh, Professor Nussberger.
I'm just reflecting on your metaphor. You say shuffling, so walking forwards, backwards, sidewards. And if you have this idea, you have a linear underlining, because you have a direction in which you go and where you measure back and sidewards. And I think actually it's more depending on the perspectives. So it's not just linear and then you can decide, but the real struggle is that we don't know the direction in which we have progress. So we have all these different perspectives, and in one perspective you can say a sidestep is a sidestep, and in the other you say it's a step forward. So I think this multi-perspectivity is not so much mirrored in your metaphor, and that's why I'm struggling with it.
Thank you for the comment. Well, I agree with you. I mean, I'd be interested in if people have ideas of what would be a better one. That came to me as something trying to think, well, it's true that I played for a while about slouching towards taking the line, slouching towards Bethlehem, the line, and wondering how, but that also has a directional sense in it. And I think that, yes, it's perhaps not the perfect image, and I think what I was trying to get across more than anything else was this sense that any movement can be read in so many different ways, and that it's important to be alert to that, and rather than to tell perhaps a more heroic sense of this is the way, which I think, reflecting back, probably in order to encourage students studying international law in Australia, at many of the universities I've taught, it was an optional subject, and the students who took it tended to be the very idealistic ones, and perhaps I'd wanted to offer these stories, I think, reflecting back, to encourage them to say, yes, stay in this is a worthwhile thing, and while your colleagues are saying, no, we'd never study international law, we only want to study tax or whatever. So this was, and then I think I probably myself definitely have thought about things in that way. And yes, but it's a good challenge to come up with a slightly, perhaps, better image. But sometimes when one is, I was thinking, when you're standing still but feeling awkward, it might be at a party, it might be in a train station, it might be anywhere. There is the sort of the steps that you do sort of just around, and you actually don't progress at all. You find you're making some movement, but you find you're actually back in the place where you started. But yeah, so that's a very good challenge to come up with a better image there.
Okay, great. We have like 5 more minutes, so yes.
Thank you so much for your presentation. Towards the end, you mentioned the idea of a great repair. And I was wondering whether that repairing can be done by international lawyers, and if yes, so how?
Yes, I was hoping no one would pick me up on this. This was my flourish at the end. And no, I've been struck by, really, and I just have to give that I understand, and this is really through my daughter who's studying architecture, who introduced me to this literature on the Great Repair, which I hadn't been aware of, which I found very interesting. And I think actually some of the first exponents of this idea were German. So the idea is, this is put very simply, and I hope there's no architecturally qualified person in the audience, and I hope she's not watching, but the idea that progress in architecture has been very much the one of demolition and reconstruction. So our state government in Victoria, where we live, has just announced we're going to demolish 40 public housing blocks, and then we're going to repair by, we're going to build completely new ones. And of course, the point is being made in our much more concerned environment about all sorts of sustainability, that actually each time you demolish these buildings and put something, even if it's better architecturally up, you're doing massive harm to the environment and all the issues surrounding the use of concrete and so on. So there's now this movement that's begun, I think, in the more critical reaches of the architectural world to think about, no, we have to face the challenge of repair, not demolishing. But so even buildings that perhaps were built, you know, that might have problems in them, we have to think about how to repair them. So I was talking about the prospect of this talk with her, and she drew my attention to some of this literature. I don't think it can't be borrowed just completely by international lawyers, but it's an extremely interesting idea that what would repair of principles mean, and how can we perhaps make, instead of perhaps always looking for normative advances, how could we take principles or accepted principles and repair them to make them appropriate for our times? So this is a challenge, and it struck me going back and reading some of the PCIJ judgments. I'm always, because now I have the great luxury of having a set of reports, this is an unknown luxury, from the PCIJ that come with each judge's office. And one of the wonderful things was, which I've done, is to go back and to read judgments of the Permanent Court of International Justice. And I'm so struck by their style. They're written in quite a different way from the way that the court has developed now. I recommend them. I think they're wonderful works of literature. And going back to, conscious that it was the 100th anniversary of the Wimbledon decision, going back and just reading that decision and to think, actually, here are some principles, the idea of collective interests, you know, that sometimes really disappeared from view and that weren't really thought about much. So my Professor Nussberger has already drawn me up on one of my, perhaps, my shuffle is not completely thought through, and you've put your finger very accurately on the other thing that's not very well thought through. But it was something that I found very rich and interesting and would like to think more about. So that's all I can offer. But I'm sure you could readily find that literature, and it's just making its way in, as I say, to perhaps the more critical parts of the discipline of architecture.
Okay, and the last question, Professor Bonnecke.
Thank you very much for your talk, very inspiring. I have a question with regard to progress in international law. Should we make a differentiation between court decisions and advisory opinions? And the ICJ has to write incredible, difficult advisory opinions in the future, I think. And would you say that a repairment of principles could be done via the advisory opinions of the court?
Well, it's a very interesting question. I mean, obviously, the court, in its advisory jurisdiction, has a different task. It's not asked to resolve a dispute between two parties, which is its essential mission when you're in a contentious case. But at the same time, the court can give its views on legal questions, and its mandate is only to give its views on legal questions. And of course, the court over the years, so far I think we have 27 advisory opinions to read from the court, which I think incidentally is exactly the same number as delivered by the Permanent Court of International Justice. We're at this interesting point that delivered 27 in a much shorter lifespan, of course, and 27 I think we have the court. And if one reads those decisions, perhaps over the years there are different approaches to the advisory jurisdiction that emerge. And there are famously times, as has been much commented on by the literature, where the court is so conscious of the political context in which it's operating, it tends to be quite limited in how it will respond. And of course, the court always has to make the first determination whether the question that it has received is possible, whether it can actually take that on. But your question does point to the fact that the difference with the advisory jurisdiction is who the court can hear from. And this is the possibility, of course, all member states, in the case of the advisory requests currently the court has from the General Assembly of the United Nations, it can hear from all of the member states of the United Nations and, of course, other organizations. And I think it's known some of the international organizations that are going to that have made written statements, and some of which will make oral statements in the Occupied Palestinian Territory advisory opinion, and some of the ones who've been recognized as able to make submissions in the climate change one are also known. So, of course, by the mere fact that the court is going to have a lot broader views before it, that means that it will have to think more broadly. And again, it would very much depend on your notion of progress, because obviously on both of those issues, which have been sent by the General Assembly, there would be many, many different views of what progress would constitute in each case. But I'd say certainly I've never been involved in an advisory opinion before. I'm a very new member of the court, so I can't speak from any personal experience, but I would imagine more as a scholar standing outside the court, having read the advisory opinions, that the court will have so much information before it that this will inevitably present a wider view of views to the court that it will need to study and deliberate on.
Okay, well, thank you very much for your wonderful observation, comments, and your speech. Thank you to the audience for the questions. So for all of us here, just to let you know, we will immediately follow with panel 4. To the live stream audience, well, thank you and goodbye. Okay.